Welcome to Topcast. Today I'm speaking with Max Velthoven. This is the first of a trio of interviews I will do here on Topcast in the coming episodes to introduce a talk each member of this trio gave in Oxford recently. So Max is the first of these. Max is a senior manager at one of the big global accounting firms, Ernst & Young, where he works as an expert on international tax law. He's got a bachelor's degree from Tilburg University in tax law, a master's in international tax law from Amsterdam University, and was awarded his PhD in 2024 also from the University of Amsterdam. And it's his PhD that we'll be talking about in part today, specifically because it invokes Popperian epistemology as applied to legal science. This video is in two parts. The first part is where I'll be speaking to Max interview style, and then we'll cut to the talk he delivered in Oxford about that application of Popperian epistemology, as well as some things he talked about with respect to AI and AGI. But also, in the first part, in the interview, we cover issues around the philosophy of law, the letter of the law versus the spirit of the law, what it means to break the law in a fundamental sense. In certain circumstances, it seems a little bit tricky what that really means. Legal loopholes and what the ethical issues associated with exploiting them might be, and what Popper had to say about the social sciences and what Max's view on all of that happens to be, as well as some other matters. Slides for Max's talk and links to Max's other work are in the links below this video. So without further ado, here is Max Velthoven. Hi Max, welcome to Talkcast. It's great to have you. We were together a little while ago where there was a gathering over in Oxford, and a number of us were drawn there for various reasons, circling around the work of David Deutsch, Karl Popper, and associated thinkers. The majority of the people that were there were scientifically minded types. And you are a scientifically minded type. However, you come from a different discipline that people might not usually associate with Popperian epistemology. So you are applying Popperian epistemology to something rather unique so far as I can tell. I've seen people apply Popperian epistemology to business. I've seen them apply it to exercise. But you're applying it to the law. You're seeing the way in which critical rationalism might be able to inform certain niche and sort of subtle ways of understanding issues in law. So before we get into the talk that we're going to be introducing today that you delivered when we all got together, which, were, as I say, was a unique talk because it wasn't about science, it was about something completely different. Tell us a little bit about, number one, how you got into law, and then how you found Popperian epistemology and what the relationship between those two things are.
Yeah, Brad, and let me start by thanking you for having me on the podcast. Very much appreciated. So indeed, at that very nice Oxford gathering, I was part of the small minority of people presenting who were not brilliant physicists or mathematicians or otherwise more in the natural science branch. But I'm a tax lawyer, so my sort of day-to-day job is that I'm a tax lawyer advising clients on their tax affairs. But on the side of that, I have been pursuing a PhD, which I've finalized last year in tax law. Well, I think your first question was how I got into the law in the first place. Well, that's because I've always in high school, maybe even earlier, been very interested in politics, in, well, the law, you could say in the broad sense, right? I think everyone to a certain extent is interested in criminal law, right? What makes someone a criminal? What doesn't make someone a criminal? How can some people get away with it and not get away with it? Those kind of questions I've always found very intriguing. But I've always also liked economics. So once I was at the university studying law, there was this possibility to do tax law, which really does combine law, economics, but also politics. So really a nice mixture of a lot of things I found very interesting. And at a certain point, I started a PhD in that. Up to that point, I don't think I knew what the word epistemology meant. And I'd never cared that much for philosophy, maybe a little bit, but really not that much. And at the beginning of that PhD, I was really looking for, well, I was quite clear on what the topic of my research would be, and we'll get to that in a minute, I'm sure. But I wasn't really sure on how to approach it, right? How to actually do research? How do you contribute anything to science? How do you go about that? And then I was pointed towards another PhD thesis that was already out there by a guy called Ivar Wendt, and he had made a unique contribution to Dutch legal research, because he said, well, we are doing a lot wrong, or at least we could do much better. And how could we do better? We should take into account the work of Karl Popper much more in our approach to legal science. And well, that started by reading his book, but then at some point I was quite sure that was going to involve a lot more other reading by Popper, by others. And I sort of said to myself, well, you've never really taken any interest in philosophy, and if you're not going to do it now as part of your PhD, then when are you? So that was the start of that, and then a couple of years later, I was in Oxford.
And you mentioned there legal science. Can you just tell me a little bit about what is the differentiation between legal science and being a lawyer? Like, is there such a thing as a legal scientist as distinct from a lawyer?
Well, I mean, there certainly, there's certainly, yes, I would say yes, but there are big questions on exactly what that difference is, right? And I can assure you that there's very contentious debates about that, right? Whether a lawyer should even be allowed to be a legal scientist as well, in what circumstances. So there's definitely questions there. I mean, I think there's pretty clearly an overlap in some cases, right? Because if you're a legal scientist, and that's also what I've written in my PhD, well, I think an important task there, and then we do go right into the Popper stuff as well, right? Is to say, okay, can I improve the law, right? Are there deficits in the law? Is something wrong? How can we improve it? And do we have explanations about why there's something that can be improved? In order to do that, of course, you have to know what the law is. And if you want to know what the law is, well, that is an activity that's also something that a lawyer would do a lot, right? A person or a company would come to you and say, look, I'm in this particular situation. What at all is the law? What applies to me? What are my rights? What are my obligations? So in that extent, there is very much an overlap. I think what a lawyer typically does much less is go about improving the law, right? You might do that on a day-to-day basis, but I think most lawyers wouldn't advise their client and say, well, the law is so, but it should be so and so, so I recommend you to take action accordingly, right? You would act according to how the law is usually, and not how it should be. Sometimes it might be a little different, but I think that's generally the difference.
That's clearer for me now. Yes, I understand. So the lawyer is just taking the law as read. It's like, here, we're going to try and apply it as it is, but the legal scientist is coming along and looking at the laws and going, well, in what way could we change this in order for things to be better? Okay, so legal science, it seems to be a little bit more meta in a sense than what just the law is or what lawyers do. And I get the sense, and you will correct me if I'm wrong, that in your thesis and in your talk, you're kind of going meta to a certain extent, because there's a sense in which you're talking a little bit about the difference between the letter of the law and the spirit of the law. Now, for anyone who's not a lawyer like me, we've heard these phrases over and again, and I kind of have a very nebulous understanding of what the distinction is. Your talk goes into a very specific case where the protagonists in the story, who are real people, are obeying the letter of the law, but there's a sense in which they're trying to get around the spirit of the law. Now, what's the distinction between this letter of the law and spirit of the law thing? And perhaps if you just want to outline that particular case in order to, illuminate for us what that difference is.
Of course, yeah, no, sure. And I think, one example that famous Dutch professor gave, which is even shorter than the case I'm going to present, this example I quite like, is, well, suppose you're living together with a partner, and your partner is going to a bar at night, and that partner says, well, I'm going to be back before 11. And then this person shows up the next morning at 10. Well, the letter the letter of the law, right? The letter of the deal has been obeyed, you could say, because that person is back before 11. But is that a correct interpretation? And if so, is it in line with the spirit of the agreement or of the promise, right? I think that is a very short example where you have, okay, well, the letter you might have agreed with or complied with, but have you complied with the intention behind that promise? Well, probably not. And I think that segues nicely into the case that I presented, and I've edited a little bit for entertainment purposes, let's say. But what it comes down to is there's two people in the Netherlands and they want to transfer real estate to each other. So let's just say a house. And if they would do that, they would have to pay real estate transfer tax in the Netherlands. And well, as many people, they don't like paying taxes. So what they found out is that if they would be married, and again, those people, they don't really know each other than their small business venture. If they would have been married, they could sort of merge within the marriage under universal title, as we say in the Netherlands, right? So their assets could be combined as part of the marriage contract, you could say. And so what they devise is a little scheme where in the morning they get married. So legally they actually get married. The marriage is actually in place. And then in the afternoon, as part of that whole wedding setup, they transfer the house to each other, or at least the house gets entered into their common assets, their shared assets. And then in the evening they divorce again, they're separated again, but the difference now is that person A used to have the house and now person B has the house, and person A now has slightly more money. And they go themselves, they go to the tax authorities and they say, well, we did this, do you agree with us that no tax should be due? And then well, something happens. But I mean, any questions on that so far, Brett?
Well, so are they contravening in this scenario tax law, or are they kind of getting around the spirit of what there must be laws? And I know in Australia there are laws around marriage, and in order to be married you first have to demonstrate a number of things. I don't know if the same thing happens in the Netherlands or in the EU. So it would seem to me that if you've satisfied the authorities on the point of marriage and they've given you the certificate, then it should satisfy the tax authorities. Or am I completely off?
Well, I would definitely not say you're completely off. I think there are specific provisions against, well, you could say fake marriages, like for example for immigration law purposes. But none of those were applicable to this scheme. And the interesting thing here, right, is for contract law, for civil law, you could say, the marriage was actually in place, right? So for example, if person A had also been involved in incurring a big liability on that same day, then person B would have been liable for that towards the third party, right? So the law, the marriage legally, it's in effect, but then the next question is, do we respect it for tax purposes?
Yeah, and so that then raises the point that if they ultimately the punchline of the story is that they weren't allowed to go through with this scheme in order to get around paying the property tax. Does that mean that they have broken the law? This phrase, you've broken the law, because they didn't obey the spirit of the law, even though they did obey the letter of the law. So if you don't obey the spirit of the law, you've broken the law. And therefore, if that's true, are they liable for some sort of penalty? I know they had to pay the tax, but could they get into even more trouble?
Yeah, no, that's very interesting, and you could indeed say they've broken the law, right? The sort of law lingo for this is called fraus legis, so abuse of law in Latin, and that condition applies in very rare cases where effectively we say, well, the letter of the law, the regular interpretation of the law, indeed gives you what you want. But we're of the view here that you've only done this for tax purposes, right? So you've only done this to save some money. And moreover, what you're trying to do or what you have done is not in line with the spirit of the law or the object and purpose of the law. It's not in line with what the law intended to do. And if that's the case, in the Dutch interpretation at least, we're going to pretend that the trick you did, in this case the wedding, was never there. So that's how that works. An interesting next question is, of course, okay, what if do you get a penalty then, right? Because you do have to pay more taxes, because you have to pay transfer tax in this case, because we're going to pretend that the wedding didn't happen for tax purposes. But the next question is, do you get a penalty? Do you have to go to jail? Do you have to pay money to the government? And in the Netherlands, at least, and I think in a lot of other jurisdictions, but definitely not all, we would say, well, if this is frauds legis, if it's abuse of law, we are saying, well, that means you've got quite far, right? Because your regular interpretation of the law was correct, but under this very niche provision, you were still denied what you wanted. We're not giving you the tax benefits you wanted, so you have to pay more tax, but you're not going to get a penalty. You're not going to get a fine, because what you did apparently did make enough sense not to give you that fine. Now, there's a lot of questions on whether that's always the case, right? For example, what if those people tried again the next day, even though they knew that the judge was not going to uphold it? Are they going to get a penalty? I think there's definitely a chance that would be the case. But generally, there is some leniency you would expect, but again, not in all countries. So don't try this at home before consulting with an appropriate tax lawyer.
Yeah. You can see exactly why. Lawyers are very useful. I mean, it gets so technical in some of these areas. You don't want to try and be an amateur in many of these situations. You mentioned the word trick there, doing something sort of kind of underhanded. But when you were giving the talk in Oxford about this, someone yelled out the word that would normally crop up in this particular circumstance, which is loophole. So a loophole is seemingly what I thought the characters in your story or actual case were using. So in general, is exploiting loopholes okay? And I'll give a case study here, and people will be aware, and we were talking about this off camera as well, that there's this famous YouTube clip that goes around, I'll probably insert it here as well, of this media mogul in Australia. He used to be Australia's wealthiest person. His name was Kerry Packer, and he was hauled before a Senate committee for a hearing where the politicians complained that he, Kerry Packer, was avoiding or evading tax. And he said he's never avoided or evaded tax. And then the politicians came back with, oh, okay, maybe you haven't broken the law, but what you've done is you've tried to minimize the amount of tax. You've tried to use loopholes in order to get around evading tax, but you're still minimizing your tax. And very famously, Kerry Packer retorted, well, of course I minimise my tax. Everyone should minimise their tax. And if any Australian is not minimising their tax, they should have their head read. And he said, and it's a very famous thing he's been saying, because it's not as if you politicians are doing such great things with the tax money that we should be donating you any extra.
What the Four Corners program suggested was not that you were evading tax at all, that would have been libellous, but that you were minimising tax.
There's nothing wrong with minimising tax. I don't know anybody who doesn't minimise their tax.
And that you were doing so in ways that were contrary to the spirit of the law.
Oh. Well, I just got through telling you what I thought about that. And what you're saying is exactly what the Four Corners program says. I am not evading tax in any way, shape or form. Now, of course I am minimising my tax, and if anybody in this country doesn't minimise their tax, they want their heads read. Because as a government, I can tell you, you're not spending it that well that we should be donating extra.
So it's this wonderful sort of thing where there's this to and fro between the politicians and the businessman, where the businessman is saying, look, you made the law. This is the law. I am obeying the law. And if there's ways I can use the law in order to minimize my tax, call that a loophole, call it whatever you want, then I'm doing the right thing. So is that in general what loopholes are about?
Yeah, no, again, a very good question, and very much on point of something we discuss as tax lawyers on a very regular basis, right? And I think, if I recall correctly, in the case that I discussed, there had in Parliament, when the new law actually on legal partnerships, right? Because they didn't actually get married, they got into a legal partnership, which is the same. Someone said, in Parliament said, this is creating a loophole. And if I recall correctly, the legislator even said, I'm aware of that, but I'm, okay, I've noted your response, but didn't take any action. And the Supreme Court didn't hold that against against the tax authorities in that case, because they said, well, even then still there can be a problematic abuse of law. What I think is very interesting in that short video that you shared is that Kerry Packer was his name.
That's right, Kerry Packer. Yeah.
Yes, he starts by actually saying, well, literally saying, well, what I'm doing right now is why the law was put into place. So he's sort of in the first instance, he seems to think that what he did was actually in line with the spirit of the new law, and then within that short 2-minute video, it sort of changes into, well, I'm not so sure whether I was actually obeying the spirit of the law, but what I did was good in any case because you're wasting my tax dollars, right? That's basically sort of how it evolves during the talk. In most legal systems, I would say there is a very firm principle or a very firm commandment in EU law, but also in a lot of countries' laws. There is a principle of legality, and from that follows the idea that as a taxpayer, in principle, you are allowed to minimize your tax burden in any legal way in which you see fit, right? So you're not obliged to do something that's plain stupid if that makes you pay more tax, right? You're allowed to structure your affairs in a tax efficient manner, but then really comes the question of the details of that, right? So for example, if a loophole is so obvious that any child that would have been in the legislature could have predicted that, does that mean that it cannot be held against the taxpayer as abuse of law, for example? Or if the legislator has been made aware of the loophole but hasn't acted, or if the legislator has acted but didn't do so in a competent manner, right? There's all kinds of sort of gray and grayer areas of where that can come into effect, and I would suppose that differs per country. But in general, yeah, there might be more leeway if a loophole is very obvious or if a loophole has been accounted for one way or another already.
I imagine as well that because just for an individual taxpayer, tax law is exceedingly complicated. I don't think it matters what country you come from. When tax time comes around, there are so many different ways in which the government is going to try and check whether or not you are entitled to a particular reduction in your tax for, buying this particular thing. You can claim this back on your tax, or you might have to pay additional tax on this thing. Just for an individual, it can be exceedingly complicated. The more wealthy you become, the more businesses you own, the more diverse your business interests, then the more complicated still the way in which you're going to have to account yourself to the government and pay what is owed to the government becomes. Is it generally the case, being a tax lawyer, that you see that courts look kind of favourably upon the taxpayer simply by virtue of the fact that tax law is so complicated that if you're a very wealthy person with many businesses, you're going to have to employ not only accountants but possibly tax lawyers like yourself just to make sure that you're dotting the I's, crossing the T's, and not doing something egregious such that you're going to end up in jail? Are the courts generally, predisposed to think it's just an honest mistake rather than, that person was evading the tax law?
Yeah, no, that's again a very apt question and something that comes up a lot. I would say, right, I mean, in the end, judges are human as well, right? So there may be judges that are a bit more legalistic and are more thinking in terms of the letter of the law, and there may be some judges that are thinking more in line with sort of the spirit of the law or their own feeling of justice, so to speak. However, there is literally an example of what you just said in the Netherlands, where a corporate taxpayer, did engage in you could say quite aggressive tax planning, but it was to get a tax benefit under a very arcane rule. It's a rule, I mean, I could show you in my textbook. I think it spans 4 pages of very small letters, but they found a loophole. And that loophole was closed actually while the case was going, but of course that couldn't be done retroactively. And then the Supreme Court also said, well, look, this rule, it's so complicated, it has so many nuts and bolts, that could go either way, right? So it could also be to your detriment, right? If you do one small thing wrong, your complete tax benefit is gone, even though maybe you would be entitled to it. Well, in this case, you've checked all the boxes, all those 4 pages, you went through, you did what you needed to do. And even though it may be a bit of aggressive, the legislator has chosen a very deliberate, very hard rule here. And that means that if the outcome is in line with that rule, then you should be able to get what you want.
Well, that's good to hear. Yeah. So if any of us make a mistake with our tax, that in general the courts are going to perhaps think, we're not trying to get around things, because it can be very complicated. We should get to Popper and your views about what Popperian epistemology, how it can inform something like legal science. Legal science would be, even though it's called legal science, would be well within the social sciences.
Yeah.
Social sciences generally regarded as things about people, things about society, way in which policy can be made, that kind of thing. In general, I would regard social sciences as not in the same way that physical science are those set of good explanations that are testable. In the social sciences, you generally won't have testable theories. And the reason you won't have testable theories is because of the inherent unpredictability of human choice. So a human choice doesn't make a difference to the outcome of your chemistry experiment or demonstration that you happen to be doing, but it's going to be everything in something like psychology. It's going to make up a lot of what goes on in economics, and it's going to have a lot to do with how we understand or interpret the law. But when you do make these policies, you need to have a Popperian view of making policies if you want to understand the distinction between good policy and bad policy. And one of the things that you highlight in your talk is this concept that Popper has of the unintended consequences. Can you talk a little bit about that, about what you think Popper's view of the social sciences was and how you think that might apply to, for example, legal science?
No, of course. And well, maybe to start there, I would say that indeed, in my view, the legal sciences are part of the social sciences, although right in the whole Popperian framework and thinking, that's not very relevant, right? There is science, you could say, or there's epistemology, and we think about problems, and whether those problems concern physics or legal science or psychology, we shouldn't really care, and sometimes they cross the boundaries of those things, so those boundaries are arbitrary and often not very necessary. Having said that, of course, within the social sciences, and that's a phenomenon which Popper also described, I think he even called it aping, there is a tendency to really look at a mistaken view of what the natural sciences do and what natural scientists do, which basically comes down to, well, they gather objective facts of the world around us, and from those facts they derive theories which get increasingly probable, or at some point even are entirely sure that they're true, as long as they found enough examples of that out there. Well, in legal science, that's already also quite hard, right? Because, as you said, you have to deal with human choices, you have to deal with human interference. But there is, in the social sciences as a whole, and in the legal sciences as well, there is quite clearly a tendency for a couple of years now to say, okay, we should also look more towards how we perceive the natural sciences act. Like, we should be more empiricist, we should do more experiments, we should do more questionnaires, those kind of things. And what Popper has actually said as well, the starting point is all wrong, because the natural sciences actually don't progress and don't make progress the way you guys think, right? So you should not be doing that in the first place, because what you should do is, as Popper says, well, you should start with a conjecture, and then you should start with a refutation or an elimination. You can do that by doing tests, and that is harder in the social sciences. But the most important part of it is actually the creative enterprise of coming up with a solution, with an explanation, and then criticizing that as part of the scientific debate. That is something that could easily be done in legal sciences, and I think actually does happen a lot in legal sciences as well. So I think that's really a good part. And you can apply that to policy making as well, right? If you go and you apply policy making in the wrong manner, so in the way in which you say, well, I think that natural sciences progresses as I just described, and I'm going to apply that to policy. So how would you go about? You would say, well, first we're going to objectively look around the world to see if there's any signs of anything that's objectively wrong, whatever way you want to describe that. Then based on that, we're gonna formulate a theory. We're gonna put that into law, and then that's great, because once that law is in effect, we can go around the world and we collect evidence, positive evidence, that our law is doing what it should. And if you're going to do that, you're undoubtedly going to find evidence, right? You're going to find maybe an infinite number even of instances in which you could say, well, here you can see that the law is doing exactly what it should do. And right, that's that's empiricism, you could say, applied to policy making. And I think the Popperian alternative, and that's also what I discussed in my talk, is that Popper says, well, a good policy debate from a social sciences perspective should not be looking at how can we confirm that the policy is objectively doing what it should, or how can we collect evidence, but it should be about, well, can we critically examine the policy before it's put into place? That's the most important part, right? But also, can we find problems, or can we find unintended consequences of the policy once it is into place? So we shouldn't be looking at evidence that it's doing what it's set out to do, but we should actually be looking for evidence, or even better, explanations of why this policy is having unintended consequences. So doing some things that it might not have been doing, or been set out to do, or even having some adverse effects that were not intended to be there in the first place.
Yeah, so you're starting with a problem as always. So going back to your original court case, if it was the case that, this policy about, well, you don't have to pay tax if you're married, you could imagine a scenario where suddenly all of these people are getting married, they're going through this facade of pretending to be married. That would be an unintended consequence of some law that's been made. And so the Popperian view is, okay, well, let's conjecture a solution to this particular problem, close the loophole, so to speak. And that doesn't mean that you're going to now have the perfect property tax law. All you're going to have is something better than what went before, and you're refuting the previous law, not because you made some kind of prediction or it's some sort of testable theory like in the physical sciences, but rather you're focusing on this idea of, we didn't intend for this problem to arise, but the problem inevitably arises everywhere all the time. We're just surrounded by problems, and so now we're going to conjecture solutions to that.
Yes.
So now you're not only a lawyer and you're not only interested in law, you're actually also an expert in the AI, AGI thing that is happening right now. And you've written a wonderful paper with your friend and colleague, Eric Marcus, who's a physicist, isn't he?
I mean, Eric is many things, because he seems to know a lot about basically every topic that you could think of. But I think he is a physicist. Yeah, that's why he got his PhD in. I would say it's very flattering of you to say that about me, but I'm not an AI or an AGI expert. What I do hopefully know a little bit about, and maybe even that part is wrong, is about the philosophical ramifications of AI and AGI, and how you can sort of tie that with the Popper and Deutsch work that we're both involved in.
Yes. I think there do not exist any AGI experts at the moment. So that's one thing we can say, is that there is no such domain of expertise as AGI. What we do have, however, is a domain of expertise known as epistemology. And so there is a divide at the moment. Just today, I was seeing Tyler Cohen, I think he's an economist or something. He was on Twitter X and announcing that AGI is just a few days away. And he's not the only one who thinks that because ChatGPT is passing the Turing test and he's having quality conversations with chatbots and LLMs, that he thinks that, well, AGI, if it's not already here, and a lot of people are saying it's here, then it's just around the corner. Now, you disagree with this, I disagree with this. Give me a few minute sort of summary of what you've said with Eric and what you think about this idea that we're already there. We've got the AGI. What are you worried about?
Yeah. No, and as I sometimes like to explain this to other people, is that, AI or the AI debate is what a day at the beach is for people that are in bad shape, is what the AI debate is for people that have, well, a mistaken philosophy, or at least a philosophy that we happen to disagree with. And the point of that metaphor is to say, well, usually, right, in a day-to-day affair or day-to-day business, you don't really talk about what someone's epistemology or philosophy is, right? You don't really talk about it, maybe in academics, but I think not even there. But the AI debate actually is a platform where even people that don't have any interest in philosophy, and I mean, good for them, right? That's fine, are saying really profound philosophical statements like, well, the human brain works by collecting data of the world around it, or humans learn by collecting as many examples as possible. And they make very profound statements, and from that they derive a very radical conclusions. So, for example, well, if you think that that's how a human progresses, well, that means that if you can make an AI or a computer that collects enough examples or collects enough data of something, then that's going to make it, well, equivalent to a human brain, or it's going to make it equivalent or even smarter than all humans combined. You can have artificial general intelligence, or even concept that goes beyond that. So that is a very interesting aspect, I think, of the philosophical debate that can certainly arise when people are trying to make statements on AI that don't really have anything to do with that. And what you do see indeed is and that's what the day at the beach metaphor relates to as well. Suddenly, it turns out that philosophically people are, well, not in shape, or at least having views that are very different to ours, because once it's time to talk about AI, everyone says, well, sure, we just need enough computer power, we just need enough that, and then we're going to have superhuman intelligence. Whereas the first question would, of course, be, okay, but what is superhuman intelligence? Does that even exist? And what is human intelligence? And what we're doing in our paper is really building on mostly the work of David Deutsch, but also Karl Popper, of course, because those two are quite clearly linked. And David has given a number of talks, podcasts, and written a couple of papers about, well, guys, hold on. AI doesn't do what you think it does. From a philosophical perspective, it's not at all equivalent to how humans think or learn. And we're not moving towards a human-like AI. In fact, actually, a lot what's happened over the recent years is moving AI away from anything that resembles human thinking, as far as David's concerned from a philosophical perspective. And what we're doing in our paper is really applying that and building a bit further on that and saying, well, if you agree with us, right, so if you agree with David Deutsch and with his application of Popper and what that means for AI, that a lot of the philosophical comments made on that are wrong, and that actually we should be thinking in a radically different manner, then what does that mean for the AI debate? And well, I think that means a number of things. One of the things it means is that, well, if you agree with David's proposition that knowledge grows by formulating and criticizing new, better explanations, AI cannot make explanations like that at this point. That means that humans are still the only universal explainers and the only ones that can make progress in the field of really growing explanatory knowledge. Sure, AI can help them, as can any other technology. It can lead to different and new problems, to better problems. It can help and assist with that, but the human remains at the creative steering wheel. And that also has various other implications as well.
There's a real philosophical divide in the culture between, I think, people who understand the mystery, wonder, amazingness of human beings as compared to any other entity that we know of in the entire universe, and the other people who think that, well, human beings are just another kind of ape. We're just slightly more intelligent than a chimpanzee. All you need to do is to give a chimpanzee a little bit more processing power and it's going to be basically a human being. And you could draw a graph and there's going to be something that is even more intelligent than what a human being is for some definition of intelligence as well. But if you forget about the term intelligence and you think in terms of explanations, then you do have this not quantitative difference between us and other animals or us and AI. What you have is a qualitative black and white difference between systems that can explain the world they find themselves in and those that can't. And by explain, it means conjecture something new and potentially make errors along the way. An interesting example I also saw recently going around on X was someone having a go at ChatGPT was making fun of it, saying this is what you think AGI is, by providing the example of a very simple arithmetic question that the ChatGPT could not get right. And many such, I've done this myself as well, and many such people have provided ridiculous examples of where, for example, I think in this case it was a decimal subtraction. It was something like 3.11 take away 3.3, and the answer that the ChatGPT gave was 0.8. So it got it completely wrong. It didn't understand what it was doing. But the point is that the person that was providing this, holding it up as an example of this cannot possibly be AGI when other people were claiming it's AGI. Of course, I don't think it's AGI, but not for that reason, because an AGI would actually be able to make that mistake. And what you want out of AI is not to ever make that mistake again, to correct it so that it's prohibited from ever possibly making that mistake. But AGI, you can't do that. By definition, you can't prohibit it from making any mistake of any size. And this is one of the things, there's so many qualitative ways to distinguish between AGI, or now I think that's also becoming almost a redundant term, because people are saying, ChatGPT's AGI when it's not. But David Deutsch also talks about the concept of disobedience, that an AGI person can disobey. I don't know if that formed part of your paper as well, this capacity to do other than the code says, for example.
Yeah, it's a good question. I'm not sure we explicitly included that. I mean, it is implicitly there, right? Because it's a creative enterprise, and as David, I think, says, well, creativity is inherently disobedient, right? And which is something that you could prove, and I'm quoting that because of course you cannot prove anything by just looking at it. But I mean, most artist types that people will know are not generally quite obedient, right? They tend to be rather disobedient, which sort of proves that point, I would say.
Now, the paper that you wrote, we will link to that as well, because I think it's wonderful. Not only does it go into some of this philosophy about the distinction between AI and AGI, but it's just it has a very good overall summary of the distinction between Popperian epistemology and Bayesianism and inductivism and all those other misconceptions that the people that circled the work of David Deutsch and Karl Popper have come to understand. Now, immediately after this, we're going to go to your talk. Is there anything you want to say about your talk by way of introduction as we segue into that, or any final thoughts before I let you go?
Yeah, well, thank you. No, I mean, I think I've introduced most of it. What I'm doing in the talk is maybe talk a little bit broader about what my research was about. I'm doing the marriage case example in a bit more detail. There is someone in the audience who liked it a lot, but who does spoil some of the moments there. But that's fine. I mean, it was a very lively debate and very good questions, actually. So that's very much appreciated. And I will also talk a little bit more about the possibilities that I see for Popperian epistemology, or for that philosophy to even make further segues into legal science. So that's what I'm talking about in a bit more detail. And the paper that I co-wrote with Eric, well, it is available online as a pre-publication, but it will also be published in a journal.
That person stealing your thunder and ruining the punchlines was Charlie Lineweaver, who was also a person who was at that conference for want of another word last year. We've already uploaded one of his talks that he gave at that conference last year, and we're going to upload a few more in the coming days and weeks, including some by Sam Kuipers and also Eric's as well, about the AI AGI thing. Thanks so much for joining me today, Max. Hope to talk to you again soon. And until then, I'll catch you later.
Thanks a lot, Brad. Thank you. Yeah, something else entirely, Popper and legal science. I'm not a physicist. I'm a tax lawyer, actually. So let's go to the quick introduction. Oh, I see. I made that animation. That wasn't what I wanted to do. Okay, so yeah, a quick intro. I'm a tax lawyer. That's my full-time job. I work at EY, a company some of you may know in the Netherlands, in Amsterdam. But on the side for the last couple of years, I've been doing a PhD research, which I was fortunate to finalize last month on EU tax law. And by some sheer coincidence, I got involved in the ideas of Karl Popper and later also David Deutsch. That's also how I eventually met Eric and Sam. And in my thesis, I've done a lot with these ideas and sort of tried to explain them to legal science. So I'm going to talk about a little bit about my work so far, mainly the PhD thesis, and then in the end, hopefully, we'll have some time to talk about a paper that I wrote with Eric on AI and Popperian and Deutschian epistemology, and a little bit about what's more to come. So I have empirically confirmed that this is the best way of explaining my thesis topic to non-tax lawyers. So it's a fictional example, but it's based on a true case, so a true court case, that is. So we have a couple of facts here. We always start with the facts. So Max wants to sell his house to Eric. That's fact one. And then we have, so that's how that's depicted. And then the problem is there is real estate transfer tax, or I think in the UK you call that stamp duty on that transfer. But Eric and Max have found out that married couples don't pay stamp duty or transfer tax when they sell stuff to each other. So,
They get married.
thanks for the spoiler. So yeah, but this is a real court case. This actually happened. So step one, Max and Eric got married. And then on the same day, you see some rings. So on the same day, they transfer the house to each other. There you go. So on the evening, they get divorced on the same day. And this case is called the flash partnership case in Dutch tax law. You can look it up if you want. And what happened there is these guys, they even went to the tax authorities to tell the tax authorities about this. And then they eventually went to the Dutch Supreme Court. And the Dutch Supreme Court, well, it first looked at the law and everything around it, and it concluded you can do this. So you can be married for a day, you can get away with this trick. It works. But there's sort of one thing we have to see, and that is whether there is abuse of law here. So that's the concept I'm going to talk about. So what did the Dutch Supreme Court see? Well, this wedding, this marriage, was only driven by tax motives. There was no love here, no other reason to get married, just purely you want to reduce your tax bill. Secondly, getting this tax benefit, yes.
They have a love evaluation procedure to do that?
And that's of course very hard, but in this case, they admitted that was the case.
Oh.
So they said, we've purely done this for tax purposes. They didn't do a fake kiss, they didn't do a fake honeymoon, it was just they said that they did that.
They should have seen their lawyer before admitting that.
Yeah, and that is, in my topic, that is the tragic actually. If you play it well, you can get away with these kind of things, but here they admitted they didn't. So then the Dutch Supreme Court looked at the law and they said, look, this is not what the wedding exemption or the marriage exemption was made for. That was not made for these kind of things. So as a conclusion, we are calling this abuse of law. And what does that mean under Dutch law? That means that we're going to pretend that whole marriage and the divorce were never there when we imposed the tax. So we had those rings, and then no, they're gone. So what do we see? We're only seeing the transfer of a house between Max and Eric, and then at the end of the day, that's how it is, and they have to pay the transfer tax.
I'm sorry, this was an actual case?
This is an actual case. You can look, in Dutch it's a long name, it's a flitspartnerschapsarrest, but I think if you do flash partnership case, you'll get it. But I'm more than happy to get you an English translation. So, what is my...
Between two men.
But it's Amsterdam, so they can do that. Yeah. What is my topic about? Well, my research is about this concept, this idea of abuse of law, that sometimes even though you're in the letter of the law, in line with the letter of the law, you can go too far. But then for corporations, so corporations, of course, they cannot get married, but they can do other stuff. They can do mergers, they can do financing together, all to reduce their tax bill. And in 2016, the EU member states got together and said, This idea of abuse of law in corporate tax, we should all have that. That should become part of EU law and should be mandatory for all of us to have. So this change, so the fact that first it was the Netherlands making those rules, now it's the EU making those rules, that's what I've researched. And usually this is about the time when people from common law countries like the UK or like the US, Australia, will tell me, well, this is a socialist concept. In our countries, you can trust the law, the letter of law, the government should never be able to do that. If you look it up for Canada, Australia, even the US, UK, similar concept exists there. So the idea that sometimes the IRS or HMRC can just come in and say, we know you're right based on the letter of the law, but you did a trick here we don't like, that notion exists in common law countries as well. So then when stumbling upon Popper, well, that happened at the beginning of my research. I didn't really have any interest in philosophy of science or any philosophy for that matter, but I thought, well, if you're ever going to do an attempt there, let's do it now, because probably otherwise you'll never will. And I found someone who said in his PhD thesis, well, we should have more Popper in the social sciences. He has not at all been successful in that regard, at least not in the Netherlands, but I think almost never. So what is the key task of the social science? So I think we discussed that already, right? According to Popper, that is to find the unintended consequences of intended human action. So you need to find, okay, if I have a new law, like mine, where does that create problems that we did not see coming? Or when would we, as policymakers, be willing to accept that the policy that we've put in place does not achieve what it does? Because it's very easy to find confirmation of why your policy works, but it's very hard to actually acknowledge when it hasn't worked. Similar to something I think you said, Brad, you talked about the perfect leaders yesterday. I think the same is true for the law. A lot of legal scientists are trying to find the perfect law, and I think that cannot be done. But you can find mistakes or problems with existing law and remove bad laws, and through that create better laws, or at least contribute to finding better laws. Well, in my perspective, Popperian legal science should be normative, right? Popper's work has a very clear ethical component there as well. We're not just describing the world how it is, but also how it should be, especially when it gets to democracy and how to create a good society. So we shouldn't just be, explaining the world, describing the world how it is. We should also explain through those explanations, improve. So if you look holistically about how traditional legal science works, I think traditional legal science is actually not even that bad from a Popperian perspective, because what a traditional legal scientist would typically do is analyze the law, look at the law, and just say what he or she thinks about that law and how it can be improved, which is quite a free-spirited way, I would say, of doing science. However, as you may know, the social sciences, but in particular legal scientists, have a huge inferiority complex towards the natural scientists. So towards these guys there, for example. So if you want to pretend, or if you want to make a good impression as a legal scientist, what you will do is you will try to mimic the natural scientists. And that is actually a phenomenon which Popper called aping, right? He's written about that multiple times, that social scientists will always try to mimic the natural scientists. And one example that he will talk about is Marx. It's a very famous one in that regard. So what you've seen during the last years, you see a lot of empirical legal research, comparative legal research, interdisciplinary legal research, all to pretend that what you're actually doing is something that resembles what legal scientists think natural scientists do. And I think Popper can provide a huge benefit there, and Deutsch obviously as well, because they not only describe how you should do social science, but they also explain how the natural science should work. And I'll just be really, actually, let's just go to that one, because I think I like that one more. So what is one problem which I identified in my particular research topic? So Deutsch especially talks a lot about self-correction, right? So when there's a bad idea, it should be removed from the system. And a key notion in self-correction, in my view, is responsibility. and that's also something Popper and Deutsch have talked about, if you have a bad idea in society, someone should be held responsible for that and should be clearly accountable. And then you can, for example, try to remove that person from power through an electoral process. If you don't have responsibility, there's a real risk that one, the bad people will stay in power, and two, the bad laws will remain in place. If you look at my topic, what I'm worried about is that you get this very murky division of competencies between the member states and the EU, and that applies to both the parliaments and the European Commission, but also to the judiciary. So a Dutch judge can very easily say, well, if you don't like this outcome, that's the EU's fault. And the EU can say, well, if you don't like the outcome, that's the national judge's fault. So no one's really taking responsibility there. And my topic, that's my proposition, amplifies that problem in this specific area. So then talk about more to come. What am I excited to work on during the next year? So firstly, many boring text papers, but I won't bother you with that one. Second one, I'd like to bring Popperian philosophy even more into the legal science than I've already tried to do. And I think a quote of Steve Jobs there that's very fitting. It's a little bit like giving a glass of ice water to someone in hell, because legal science currently from a methodological perspective and a philosophical perspective is just not good. And then Popper and AI, and maybe Eric, yeah, that's a nice moment to talk about that paper a little bit more, because we wrote a paper together for a conference, and actually to circle back to Sam's contribution in the beginning, Sam talked a lot about all kinds of mistaken epistemologies, right? Bayesianism, inductivism, empiricism, and those ideas are very, very present in all the debates on AI. And what we've tried to show in that paper is that that's not only a problem from a theoretical perspective, but that also has real world implications. So for example, if you look at, Eric talked about AI in medicine, but there's also AI in tax authorities, for example, where in the Netherlands we've seen that tax authorities have, on quite a massive scale, employed AI to surveillance people, but also to find out which kind of groups of people had to be audited. And because they couldn't really explain why people were targeted, it turned out that they were targeting by nationality, for example, or by, things like that, maybe even religion. And that is something that we would argue has a lot of interaction with the fact that there's bad epistemology behind a lot of the reasoning. Because if you think, well, the only thing we care about is that it works and not why it works, you're much more prone to have those kind of mistakes. Yeah, and this is one idea which I really like about, which I put in my thesis as well, is the idea of Popper and the matrix. Because as you'll know, Popper is quite famous for his big rebuke of Plato, right? That's the open society and his enemies. And in some passages of Popper's, he talks about Plato's famous cave analogy, which I guess a lot of people will be familiar with. So what's interesting about the cave analogy is that usually when people talk about that, it's about reality might be fake, or we all have a perception of reality that may be mistaken. But what Popper does is he places this analogy in where it should be in Plato's thinking, is that Plato says, well, this analogy is actually part of a much broader view, namely the worldview that there should be a philosopher king. So there is indeed a cave, but some people can escape from the cave and they can see the real reality. And in Popper's story, that is the philosopher king. He's the one who can get up from the cave, discover reality, and then reign over everyone who cannot do that. So if you apply that to the Matrix, you may actually get a very different opinion on Neo, because we all think Neo, Keanu Reeves, great guy, trying to save humanity. But if you place him in Popper's reading of the cave analogy, he's maybe a hero in disguise, because actually he's a tyrant in disguise, because what he's doing is maybe not only trying to save humanity, but he's actually also the one who will reign over everyone, even though he's in the movie, of course, he's very nice, and in the end he sacrificed himself. But it's, if you apply Plato's cave analogy to it and how Popper sees that, it's actually a commercial for tyranny and not just a nice story. Yeah, maybe one last thing, and we briefly discussed it before this talk as well. So the idea of reality of abstractions of Deutsch, which I believe we talked about yesterday as well, is something which the legal science has absolutely not taken any account of, which means that if in the legal science you want to pretend you've really researched something, you need to go down to the lowest level of detail that you can find. You have to find the most obscure niche proof, and that's usually the best. Usually more abstract, more higher level explanations, they don't do well in legal science, and I believe, of course, that is something that should change as well. And maybe the last one, and this is one I quite like, is the concept of a good explanation within the legal system as well. So it's not entirely the same notion of explanation that Deutsch or Popper would have, but I think it's fairly similar, and that's the idea of what we call a taxpayer position or a tax filing position. So basically what it is if you take a position in your tax return and that turns out to be wrong, obviously sometimes you can get a penalty or you can even go to jail. But in some cases, the judge may find that even though your explanation is wrong, it was still good enough for you not to get a penalty. So an example I have put here is a bad explanation would be, well, I had lunch, here's my lunch receipt, and I'm declaring that lunch receipt as tax deductible because today it's great weather. That's a bad explanation for trying to take a tax deduction. A good explanation could be, well, I'm treating this lunch receipt as tax deductible because I have a statute of the law which, in my view, provides me the basis to do that. So I think that would be in line with the text of the law. In the first case, you're very likely to get a penalty, right? You've made up a very bad explanation and you've taken the tax position, that's tax fraud, you may even go to jail. In the second explanation, in many jurisdictions, the judge will say, well, you were wrong because I think the statute should be interpreted differently, but I'm still not giving you a penalty or putting you in jail because your explanation somehow, and it's very hard to exactly define where the border is, reached a certain level that made it good enough, even though it turned out to be wrong. And again, this idea of explanation is a little bit different, I would say, than what Popper and Deutsch say is an explanation, but it's still very interesting because it is an example where within the legal system, the notion of explanation is used to make a very crucial distinction, namely if you whether you go to jail or not.
That sounds like a good lie rather than an explanation.
The first one.
The second one.
The second one?
Yeah, that's a good lie. You should say, hey, whatever I interpret it according to, I don't need to know the law, I just say it's consistent with my interpretation of the law. That's just what a good liar would say.
Yeah, but it's not my explanation. It has to be a literal explanation. So you have to have a literal interpretation of the law. You have to be able to show the statute.
Oh, you do?
Yeah.
Oh, I thought
Yeah. No, you have to.
Just to say.
No, you cannot just say, I think that's how the law works. You need to actually show the law. Yeah.
All right, that's.
No, my job's not that hard, but it's not that easy. Yeah. So yeah, a couple of examples there. I think maybe Eric, we can talk about the AI one a little bit more. Any questions?
Could you say a bit more about the EU, like your actual research topic? Like, how far have you got with that? What do you think the answer is?
Sure. So, well, the interesting thing is that the European Commission has literally just released a public evaluation of this topic. So I'm sending in my PhD as a response to that. So in terms of actual changes, nothing. I think where
Sorry, so is your conclusion that this is just bad and
I don't. Well, I don't think it's. I don't think it's. Well, I think from the if you look at the perspective of the methodology I use, right? So the Popperian Deutsche notion of how should you do policy making, this is very clearly bad. And from the Deutschian perspective, you could do that very easily because Deutsch thinks the whole EU is a bad idea based on the fact that it undermines self-correction. So I guess this would just be one part of that. If you answer it a bit more detailed, I would say where we have some clear self-correction defects in my topic is that if you want to look at what the object and purpose of the law is, so what is the spirit of the law, you need to have a very good understanding of what the law is, right? There might be some religious people, for example, in the wedding case, that would say, I don't care that someone was only married for one day. In my view, a wedding should always be respected by the law because it's a holy thing, and we should never pretend that it was not there from a tax perspective. That is a pretty fundamental question on how you think the law is. And where I think we'll have big problems is that when a European judge wants to really know how the national member states' laws work, they have very defective procedures of doing that, and that should be much more transparent and it should be much more accountable. And there's very easy ways to do that, actually. So I've provided a couple of recommendations for that.
You mentioned self-correction and Brexit, and I think in a couple of economist articles I've read, they talked about how Brexit undermined the self-correcting of the EU because in a lot of ways Britain was slightly different, and they would always say, wait a minute, what about this, what about that? And so after Brexit, England was no longer there, or UK had no voice to self-correct the legislation that was coming out of something that's a larger unit. So although it might have been good therefore for self-correcting of UK, it would be less good for the self-correcting of the European Union as a whole. So that's all. It's a comment, I guess.
Yeah, well, I mean,
in terms of self-correcting, it's not obvious which one promotes, or it depends on self-correcting at what level.
No, I agree, and I think from a self-correction mechanism, the worst example of that is Norway, because what Norway does, Norway is not in the EU. Norway actually pays the EU to be able to adopt its laws. So Norway pays to borrow the EU's laws, basically. And the only thing Norway gets to do is it gets to send informal recommendations ahead of the legislative process.
Why don't they just steal them?
Well, because I think there is literally sometimes technical detail in what you need to do. So you need to
patented or something.
sometimes because it can be very detailed, right? It can be the description of how big, I don't know, like an implant has to be in order to be able to be imported into the EU. It's quite technical knowledge sometimes. Right. And Norway just, ahead of the legislative process, just sent an informal letter saying, well, designing these laws, could you please take account of this and that? And they have no way of enforcing it. They only just pay.
So at the start of your talk, you have the example of two people getting married and then transferring the house. And I've always wondered, to what extent do you think that there is a lack of self-correction there? Because one of the things I always find odd about the example is that the tax authorities have an interpretation of the spirit of the law, which doesn't seem very well defined. So they, typically, at least I think in common law, your intention matters only to the extent that you can prevent more harmful crimes from being committed. So like if you're entering a house and you have a knife on you and there's someone in the house that you're clearly intending to murder, then you say, we're going to try for murder because that is the harm that we're trying to prevent you from committing. But this seems different. This just seems like there is a kind of loophole in the law which we want to avoid just because we don't like it. We want to be able to tax these people. So isn't that kind of like an easy to vary explanation? You can say, we wanted to tax you, so now the law doesn't really apply in the way you think it does, or and how is that related to self-correction?
Yeah, well, I mean, that is true. It is a very easy way sometimes for the tax authorities to use that, which is why a lot of people say they should only use that as a backstop, right? If all else fails, and then only very occasionally you should be able to use that, and otherwise you should not. But there is a certain arbitrariness in coming up with what the law is intending to do.
Yeah.
And I think that is indeed an important problem when you're going to have that question not only answered by a Dutch judge, but in a dialogue between a Dutch judge.
Yeah.
And
I'm sorry to cut you off, but I can see